So you commute in. It's not bad. The winter.
Good afternoon, everyone. The Subcommittee on Water, Oceans, and Wildlife will now come to order. We are meeting today to hear testimony on 3 bills related to tribal water rights settlements. Under Committee Rule 4F, any oral opening statements at hearing are limited to the chairman and the ranking member. This allows us to hear from our witnesses sooner, helps keep members on schedule, and so I will ask unanimous consent that all members' opening statements be made part of the hearing record if they're submitted to the clerk by 5 p.m. today or the close of the hearing, whichever comes first. Hearing no objection, it is so ordered. I also ask unanimous consent that Representative Gallego and Gosar from Arizona be allowed to sit on the dais and participate in today's proceeding. Hearing no objection, that too is so ordered. I will now recognize myself for 5 minutes. I want to thank everyone for joining us for an important hearing examining 3 tribal water bills. This is an opportunity to learn more about tribal water rights settlements, which both quantify the amount of water a tribe is legally entitled to and provide the infrastructure needed to deliver and treat that water for tribal communities. The federal government has a long-standing trust responsibility to protect tribes' rights to access and use the water resources that they're entitled to. However, many tribal water rights today still remain largely undeveloped and unprotected. This has left many Native communities across the country without clean, reliable water. Tens of thousands of people across Indian country live without running water in their homes, even though tribes often hold the most senior water rights in many river basins under the law. Fortunately, there's a solution in many cases. Negotiated water rights settlements allow tribes, states, and the federal government and other water users to come together, resolve competing water claims, and provide tribal governments with the resources to bring clean water to their people. Tribes could seek access to their water by going to court to quantify and enforce their water rights, but litigation, as we know, is lengthy, divisive, costly, and uncertain. Negotiated settlements have been the preferred avenue to resolve tribal water rights since the 1970s, not only for tribes, but for states and for the federal government under both Republican and Democratic administrations. The policy of pursuing negotiated water settlements makes a great deal of sense from the federal perspective. When tribes have outstanding claims to water rights, the federal government is at risk from lawsuits for failing to protect those rights. Protecting tribal water rights is, after all, a federal trust responsibility. Negotiated water rights settlements are also preferred by states and other water users who face great uncertainty from litigation. Tribal rights, if fully quantified and exercised, could push other users down the list of priority water rights and jeopardize their water supplies. Negotiated settlements negate that risk and the uncertainty that goes with it, while providing access to water for communities that have historically been deprived of it. Simple fact is that negotiated settlements are virtually always a good deal for everyone involved. They bring water to tribal communities, they reduce legal, financial, and water supply uncertainty for all settlement parties. I look forward to discussing how the settlement negotiation process has worked for the tribes who are before us today, and how Congress can better support the development of desperately needed water infrastructure for Native communities. One of the bills that we'll discuss today is H.R. 644, the Navajo-Utah Water Rights Settlement Act, sponsored by Ranking Member Bishop. This bill authorizes the Navajo-Utah Water Rights Settlement Agreement, which would resolve the Navajo Nation's federally reserved water rights claims within the state of Utah and provide funding for water supply and treatment infrastructure. The Utah chapters of the Navajo Nation include more than 2,500 households, nearly half of which lack indoor plumbing. We'll also examine H.R. 2459, the Hualapai Tribal Water Rights Settlement Act, introduced by Representative O'Halloran of Arizona. This bill would authorize the second and final phase of the Hualapai Water Rights Settlement, which quantifies the tribe's rights to Colorado River water and provides infrastructure to deliver that water to communities on the reservation. I understand the administration has expressed major concerns with the current version of the proposed settlement, and I hope to more closely examine the administration's basis for those concerns today. Finally, H.R. 3292, sponsored by Representative Lujan, would amend the Amat Litigation Settlement Act to provide additional time and funding to complete crucial water infrastructure for 4 pueblos in the Santa Fe, New Mexico area. As we'll see today, every settlement is different, But the negotiation process allows tribes and other water users, the state and the federal government to come together and develop a tailored solution that benefits all parties. While this committee will further explore the details of these three bills, I want to commend the bill sponsors for introducing legislation that aims to resolve disputes and get clean, reliable water to these communities that currently lack that water supply certainty. With the changing climate and strained water supplies, now more than ever, Native communities need resources to build and improve their water systems. Indian water rights settlements will continue to play a critical role in meeting that goal, and many of the tribal communities have lacked reliable water for decades, in wet years and in dry years. It's time to bring about greater equity in terms of our infrastructure investments and water deliveries. And with that, I will close and recognize Ranking Member McClintock for 5 minutes.
Thank you, Mr. Chairman. If only we could have that water reliability in California, but that'll be for another day. The subcommittee meets today to hear three water rights settlement bills involving the Navajo, Waukee, and Amat Indian nations. In the landmark 1908 case of Winters versus the United States, the Supreme Court ruled that when Congress recognized Indian tribal sovereign rights within their reservations, the right to all resources within those reservations was implicit. Without the right to water resources within those lands, the lands themselves were worthless. More than a century later, we are still grappling with the rightful apportionment of these rights. Tribes with unresolved Winters claims typically assert them with the federal government and attempt to negotiate a mutually agreeable settlement in lieu of a lawsuit. Now, when three such bills came before this subcommittee on September 30th of 2009, I was serving in this same capacity as ranking member, and here's what I said at the time. It's important that these claims be settled. They involve some of the oldest standing litigation in the federal court system. They establish something that the people of their regions, both on and off reservation, have lacked, and that is a certainty about future water rights and apportionments. These are settlements of outstanding litigation involving the United States government. It seems to me that the only relevant question is whether these settlements are advantageous to the government compared to its likely liability under current law. If we were the board of directors of a private corporation deciding whether to approve a negotiated legal settlement, we would be guilty of breaching our fiduciary responsibility to our stockholders if we made that decision without consulting legal counsel. The administration has expressed reservations about all of these bills, and that should be a warning to us. What troubles me most is that we have been unable to get a straight answer to the most important question at issue, and that is, do these settlements exceed the likely liability of the government if these claims were to go to court? Or to be more blunt, are we cutting our losses, or are we giving away the store? Unquote. Well, the sentiments I expressed in 2009 were made into a formal protocol by Mr. Bishop when he became chairman of the Natural Resources Committee in 2015, and have guided our consideration of such bills ever since. 10 years later, that remains the central issue before us. Last month, I sent a letter to the Departments of the Interior and Justice, as well as to the Office of Management and Budget, requesting they continue to follow the Indian Water Rights Settlements Protocol put forth by Mr. Bishop. Under that protocol, we've advanced 3 settlements through Congress. Only one of the settlements before us today has received a letter from the Departments of Interior and Justice pursuant to that protocol, and that's H.R. 644, sponsored by Mr. Bishop. I have concerns with the other 2 bills. H.R. 2459 is essentially the same bill Interior testified against in just the last session of the Congress. As we will hear today, Interior believes the cost to construct a 70-mile pipeline from the Colorado River, lifting water over 4,000 feet in elevation, will be significantly greater than the amount authorized in this bill. That concern is borne out in our third bill, H.R. 3292, which adds $150 million above what we had previously paid to settle the Amat claim in 2010. We settled that case for $50 million, yet we have us a bill before us right now that literally quadruples the cost of that settlement. Now, the reason is that H.R. 3292 made taxpayers liable for specific projects that had been significantly lowballed. We thought we were settling for $50 million. Now we're finding the cost is $200 million. H.R. 644, introduced by Mr. Bishop, avoids authorizing specific water projects and instead creates a water development fund to be used by the Navajo Nation to build water projects on an as-needed basis. This allows the Navajo Nation the opportunity to achieve economic efficiency and flexibility in designing and constructing water projects over time as the needs arise, while protecting taxpayers from cost overruns or footing the bill for delays or an increase in design and construction costs. This settlement model ensures that the total cost of a settlement to all parties does not exceed the value of the existing claims as calculated by the federal government. I would urge the majority to consider this as we take up these bills. Yield back.
Thank you. We'll now hear witness testimony. Let me remind our first witness that under committee rules, witnesses must limit their oral statements to 5 minutes, but your entire written statement will appear in the hearing record. When you begin, the light on the witness table will be green, and Mr. Mickelson knows this, but it'll turn yellow at the 1 minute point and then red when it is time to wrap up. I will now introduce the first panel, which consists of one witness, a very good one though, and it is indeed Alan Mickelson. He's a senior advisor to the Secretary of Interior for Water and Western Resource Issues. He also serves as chair of the Working Group on Indian Water Rights Settlements at the Department of Interior. Welcome, Mr. Mickelson. You are recognized for 5 minutes.
Thank you, Mr. Chairman. Good afternoon, Mr. Chairman, Ranking Member McClintock, and members of the committee. As noted, I am Alan Mickelson, Senior Advisor to the Secretary and Chair of the Department's Working Group on Indian Water Settlements. Thank you for the opportunity to appear before you today to testify on behalf of the Department. I have provided my full written testimony as noted for the record, which I will briefly summarize for you now. H.R. 644, the Navajo-Utah Water Rights Settlement Act, would resolve all reserved water right claims of the nation in the Utah portion of the reservation. The United States and the nation agreed to a fund-based settlement to afford the nation economic efficiency, greater flexibility, and tribal self-sufficiency in meeting its future water needs. The Department worked with the nation and the state of Utah to develop consensus legislative language that is reflected in the current Senate Bill S-1207, which the Department supports. H.R. 644 is largely consistent with the language in S-1207, but there are minor inconsistencies. The Department looks forward to working with the bill sponsor and the committee to rectify these minor inconsistencies. H.R. 2459, the Wallapai Tribe Water Rights Settlement Act, would resolve the tribe's remaining water right claims in Arizona and authorize funding of $173.5 million for the purposes of designing, constructing, operating, and maintaining a 70-mile pipeline from the Colorado River in the Grand Canyon National Park, lifting water over 4,000 feet in elevation. The Department has serious concerns with the legislation as drafted and cannot support the bill. The Department is particularly concerned about, first, the waiver of protections for the Federal Reserve groundwater rights, which significantly compromises the tribe's water rights and establishes a deleterious precedent in Arizona and throughout Indian country. Second, the size, scope, and cost of the project given current and projected tribal water uses. And third, the accuracy of the cost estimate, which is based on an appraisal level study, which is insufficient basis for determining the true cost of the project. We also believe there is a less costly water supply alternative that potentially meets the needs of the tribe and warrants further assessment. And finally, H.R. 3292, the Amat Litigation Settlement Completion Act, would amend the Settlement Act to provide additional authorization for appropriations to substantially complete the Waukee Basin Regional Water System in order to preserve the Amat settlement. The bill would also adjust certain dates in the Settlement Act. The Department has been working very closely with the 4 settlement pueblos, the state of New Mexico, Santa Fe County, and the city of Santa Fe on what we call a 611G agreement concerning a revised design for the Waukee Basin Regional Water System and the federal and non-federal cost share of additional funds needed to complete its construction. We concluded the negotiations late last week, and the department is now going through the process we use to approve that agreement. The department has been working with the New Mexico delegation on this legislation and is supportive of the goals of the bill. We need to work out a few provisions that we are confident can be addressed in a substitute amendment. The department remains committed to the successful implementation of the Amat settlement, and we look forward to working with the parties, sponsors, and the committee to craft a bill we can fully support. Mr. Chairman, that concludes my oral testimony, and I am happy to answer any questions members of the committee may have.
All right, thanks very much. We'll now recognize the members of the committee for their questions, and I will begin by recognizing myself for 5 minutes. Mr. Mickelson, I want to ask you about the concern you have expressed with a provision in the Wallapai settlement that prohibits a tribe or the United States from objecting to any use of groundwater outside the boundaries of the reservation, even if those uses interfere with water reserved for the tribe's use. I'm hoping that you can explain for us why you think this provision is inappropriate in this settlement.
One of the alternatives we believe that exists on the Wallapai Reservation with the Wallapai Nation is a significant amount of groundwater that could be developed at a much lower cost than the water out of the Colorado River, and we believe that the protection of that groundwater is a trust responsibility that we have.
So along similar lines, you've criticized the scope and size of the Wallapai settlement, and I'm hoping to understand a little more specifically. Are you concerned with the total cost of the project? Is it the number of people served by the project? Please elaborate, if you would, please, on exactly what you mean when you speak about the size and scope being a problem.
The concern that we have there is primarily financial, and we believe that the $173.5 million estimate that is in the bill is substantially less than what it would take to actually construct that project. And to be frank, we don't want to find ourselves in another Amat situation.
Okay, thank you. And this obviously is a settlement involving infrastructure delivering surface water. But when discussing a previous version of this Settlement Act in the Senate last year, you spoke about the concern that the settlement should evaluate the water rights, water availability, and water resource needs of the tribe from a holistic viewpoint, including additional groundwater study before you'd be able to take a position on this surface water settlement. Does the administration still believe that an additional groundwater study would be needed in this area before it'd be able to support a settlement?
Mr. Chairman, thank you for that question. The short answer to that question is yes. And to elaborate a bit further on that, we are actually wrapping up groundwater studies literally as we speak. We expect to have a USGS report formally out early next year. We've seen preliminary indications and have had preliminary discussions with GS, which we would be willing to share with the tribe concerning the availability of groundwater.
All right, thank you. Moving on to the Amat settlement. That settlement legislation includes a process for resolving potential cost overruns, Section 611G. And I understand Interior has been in some active discussions with the parties in determining a new design for the regional water system that Congress approved in 2010. So I wanted to ask you, did Interior and Congress anticipate that there may need to be additional funding to build the regional water system?
Another good question, Mr. Chairman, and I would actually refer you to past history of this particular settlement where Mike Connor, who was Commissioner for Reclamation and ultimately Deputy Secretary of Interior in the previous administration, testified that the authorized amount was probably not going to be sufficient to construct this. This has been a long anticipated problem.
So on this issue of a provision to resolve potential cost overruns, we talked about that in the context of the Amat settlement. Do you think that we could include a similar provision in the Wallapai legislation? Do you have any view on whether a similar provision should be included in the Wallapai legislation?
I don't mean to sound negative or anything, but obviously Congress can do what Congress wants to do. It would be our recommendation and our position based on the experience that we have had that fund-based settlements are a much more viable alternative going forward on the vast majority of these settlements.
All right, thank you for your testimony. The chair now recognizes Mr. Gosar for 5 minutes.
Thank you, Mr. Chairman, and I greatly appreciate the opportunity to participate in this important hearing. I'm thrilled that we have 3 Arizona witnesses here today, and that speaks volumes about the importance of water in the West, particularly in Arizona, and the bills being discussed. Chairman Clark, President Nez, Director Broshotsky, it's great to see you all, and thanks for making the trip. Let me start by saying I have great respect for what is known as the Bishop Protocol for water rights legislation. This protocol has worked in the past, as we saw with the Blackfeet Water Rights Settlement Act passed in December of 2016. Having said that, I have introduced the Phase 2 Wallapai Water Rights Settlements Act in the past, and I'm proud to support efforts to secure a final water rights settlement for the Wallapai tribe again this Congress. I would also like to point out that I'm the sponsor of Phase 1 settlement, which passed this body and was signed into law in December of 2014. Completing Phase 2 is extremely important to the Wallapai tribe and to numerous stakeholders and water users in Arizona. I would also like to point out the bill is supported by the entire Arizona federal delegation, with the exception of Chairman Grijalva, who I assume is likely not a co-sponsor because the bill is moving through his committee. 11 of the 22 federally recognized tribes in Arizona have unresolved water right claims. Settling these claims and providing certainty for Colorado River users and local communities has been a priority of mine since running for Congress. This bill is about providing water for people, and Phase 2 settlement will allow for water to flow to the tribe's main population center in Peach Springs. This bill would also provide a water supply to Grand Canyon West, home of the Skywalk, a huge income generator for the tribe that receives more than 1 million visitors annually and provides numerous benefits to Arizona and local communities. I would like to add that I am thrilled that the members of the majority support H.R. 2459, especially after all the rhetoric and false narratives that have been spent time on the last couple of weeks with regards to opposing responsible mining outside of the Grand Canyon. It is particularly encouraging that they have come to their senses on this bill and put the interests of people ahead of the interests of extremist environmental groups. By supporting this bill, the majority also supports important infrastructure and development occurring in the Grand Canyon, including responsible construction of a transmission line, pump station, and water plants, as well as a 70-mile pipeline. I hope that we can all build consensus in this bill and that the majority will also support other worthwhile economic and infrastructure opportunities for local communities in northern Arizona. We can protect the environment while moving forward with responsible development and production. All right, let's get back to questions. Mr. Mickelson, it's great to see you again, and I appreciate all the good work at the department. I want to discuss the non-federal cost share in the settlement. In your written testimony, the only non-federal cost share you mentioned in relation to the settlement is Arizona's $3.25 million cost of firming part of the CAP water that you indicated you find that to be inadequate on the non-federal contribution. But I want to call your attention to Section 5D1B of the 2014 Bill Williams Water Settlement, which states, the contribution of Freeport Corporation to the Economic Development Fund of the tribe shall be considered to be a non-federal contribution that counts toward any non-federal contribution associated with a settlement of the claims of the tribe for rights to the Colorado River water. Given that section of federal law, does the department recognize the $10 million contribution that Freeport made to the tribe's Economic Development Fund as a non-federal cost share to this settlement as the 2014 statute expressly directs?
Thank you for the question, Congressman. The department does not believe that the contribution of a private corporation is the same as a contribution of the state.
But it's directed by Congress. And you just made the comment in regards to the dictations of Congress. It's so willed within the dictation. It's the will of Congress. And I mean, yeah. I gotta tell you, Article 1, Section 8 of treaty obligations is a purview of Congress.
I would say that the size of, let me back up and just say that I think it is our position that.
Let me ask you a question instead.
Okay.
Was there any note by the Interior that this wouldn't consider at the passage of this bill? I don't think so. There was no ire brought up by Interior in regards to the settlement. So it sounds to me like they were complicit in regards to my interpretation of that finding.
Gentleman's time has expired. The chair now recognizes Ranking Member McClintock for 5 minutes.
Thank you. Mr. Mickelson, first could you just briefly go over the benefits of a fund-based settlement such as H.R. 644 compared to a project-based settlement like H.R. 2459 or, for that matter, the Amat bill?
I'm sorry, what was the question again, Mr. McClintock?
Benefits of a fund-based settlement as opposed to a project-based settlement.
We believe that a fund-based settlement provides finality to the United States. It's accompanied with the same waivers that we would get in a project-based settlement, and we frankly have not had great experience with project-based settlements.
As shown by the Amat bill, where we settled for $50 million and find out, oh no, actually that's going to be $200 million plus. And that's important for us because we need to know from you what our liability is, and then we need to decide whether the settlement is in the interest of the taxpayers or whether we should go to court. And if we're getting lowballed figures on these settlements that we soon discover are 4 times the size of what we thought they were, we're not making rational decisions, are we?
Well, I mean, we pointed out in testimony, like I said, in 2010 by Commissioner Connor at that time, that we had concerns about the authorized amount.
And you said that the pipeline project in the Waukee bill is going to become an Amat bill 3 or 4 years down the line, right? We're going to be presented with huge cost overruns as far as you can estimate the cost of this project. Is that correct?
We believe that's
now, the project itself, the pipeline itself, as opposed to operations and maintenance, about $135 million. Is that correct?
Are you talking about
the pipeline project itself?
No, yes, for the pipeline project itself, plus construction of power lines and things like that, it comes to 173.5.
And you think that that figure is a lowball figure? Then the question I would need to ask is, okay, if that's the low end, what's the high end? How much could we end up being on the hook for?
Reclamation is estimated that could be as high as $350 million.
Okay, so we could be settling for $350 million, not the $175 in the bill, or $135 that's the actual cost of the project. Why can't we just set a dollar limit then in the bill itself? We'll pay for this much of the project. If there are any cost overruns, then the Wallapai would be responsible for the rest.
Well, again, I think that's up to Congress to make that determination.
There's no reason why we couldn't do that.
There's no reason why you couldn't do that.
We wanted to protect the taxpayers against the same kind of cost overruns as we're now confronted with on the Amat bill.
Correct.
All right. I guess that's pretty much all I've got then. The concern is simply one other question, and that is, what is our actual liability if this case were to go to court?
I would have to go back and refer to what we call the assessment and recommendation report and Justice's figure in that. I don't have that at the top of my head.
I wonder if you could go back and do that and basically come back and advise us on what is our liability if this goes to court, so that we can then make a rational judgment of what is in the interest of the taxpayers to settle for, and to place a cap in the bill to assure that we don't have a cost overrun that we've already accepted liability for.
I would note two things on that. We have met with the tribe and given them a figure that we believe that we can support from an administration perspective. And then the second thing is that I would caution people when we start talking about liability in that it's not just simply court-ordered liability payments, but we also have, in my opinion, and I think in the opinion of the department, in some instances, moral and ethical obligations to make sure that tribes receive an adequate supply of water. We've got a lot of these tribes.
Of course, I mean, that's our responsibility under the Winters Doctrine, and I couldn't agree with you more. But there's a difference between meeting that responsibility and meeting that responsibility plus an enormous additional liability to taxpayers. That's what it's our job to protect them as well as to protect the tribes. And I just hope that you will be able to share that figure with us so that we can put that in as an upper limit on the amount of liability that the federal government is accepting in this project.
We have not sussed this figure, I guess, for lack of a better term, through our working group yet, but we have told Wallapai that we could support a settlement of somewhere between 60 and 80 million.
Mr. Chairman, can I ask for a point of clarification?
For what, I'm sorry?
For a point of clarification to the witness.
Well, we're out of time, but I'll indulge a
Yeah, I would
clarification.
like the department to reevaluate after the findings that I presented and get back to us with the comment in regards to that Freeport donation that was dictated by law.
Okay, and Mr. Gosar, you're welcome to submit written questions as is the normal course to the witness. I will now introduce witnesses for our second panel. We'll thank Mr. Mickelson for his testimony. Let me remind the second panel, as you come forward, to limit your oral statement to 5 minutes. Your entire written statement will appear in the hearing record. As we said before, when you begin, the light will be green. At the 1 minute remaining point, it'll turn yellow, and when it turns red, it is time to wrap up. We'll let the entire second panel testify before bringing it back to the members for questions. But in terms of the batting order and who we're going to hear from, it's changed a little because President Jonathan Nez of the Navajo Nation, I think, has a plane to catch. So we're going to take him first. Welcome, President Nez. Next, we will have Mr. Norman Johnson, the Natural Resources Division Chief of the Utah Attorney General's Office. Third will be Chairman Damon Clark of the Wallapai Tribe in Arizona. And finally, we'll hear from Mr. Thomas Bushatsky, Director of Arizona Department of Water Resources. The chair now recognizes President Nez for 5 minutes.
Good afternoon, Chairman Hoffman, Ranking Member McClintock, and members of the Subcommittee on Water, Oceans, and Wildlife. My name is Jonathan Nez. I am the elected president of the Navajo Nation. Joined with me today are members of the 24th Navajo Nation Council. Those are members of our tribal lawmaking body, and also our staff and relatives. Thank you for this opportunity to present testimony on H.R. 644, the Navajo-Utah Water Rights Settlement Act. I also wish to convey the gratitude of the Navajo Nation to Representative Rob Bishop, Utah Governor Gary Herbert, Lieutenant Governor Spencer Cox, and the many co-sponsors of this legislation for their support and leadership in ensuring that the Navajo people in southeastern Utah have the basic modern convenience of running water. I'd like to first provide some background on the Navajo Nation. We are a very large sovereign Indian nation with approximately 350,000 citizens. We have the largest Indian reservation in the United States, in the states of Arizona, New Mexico, and Utah. We have lived on our ancestral lands within the 4 sacred mountains since time immemorial. You have probably seen Navajo lands without knowing it in tourism brochures, car commercials, movies that showcase the red rock stone mittens near the Grand Canyon. The beauty and the grandeur of our lands cannot be overstated. We have long governed ourselves and have a society that honors our culture and tradition. But we have also adapted to survive and thrive. Today, we have a 3-branch government, and our elected officials are responsible for ensuring that our citizens have the necessary services and programs on the reservation. Our members have served with distinction in the military at the highest level of government and many different professions with a commitment to serving our community. We also continue to face incredible challenges, from high unemployment and poverty levels to many social ills, health disparities, and other disadvantages. But we are resilient and tireless in our efforts to overcome those challenges and build opportunity and hope for our people. That is why I'm appearing before you today. I have come before you to ask for this body's approval of a settlement that will provide Navajo people in Utah with the basic modern convenience of running water and a potable water supply. The challenges of providing access to water on the Navajo Nation are monumental, and the conditions are dire. More than 40% of Navajo households in Utah lack running water or adequate sanitation in their homes. In some cases, such as in the community of Aljeto on the Arizona-Utah border, a single spigot on a desolate road miles from any residence serves 900 people. The legislation we are presenting today will address these critical needs of the Navajo people. The legislation ratifies an historic water rights settlement between the Navajo Nation, the United States, and the state of Utah. The settlement sets a quantity of water aside for the nation's use, specifically 81,500 acre-feet per year, and provides critical funding for water infrastructure for Navajo Utah communities. The legislation authorizes the appropriation of approximately $210 million for a trust fund that will be conveyed to the nation, with $198,300,000 dedicated for planning, design, and construction, and $11,100,000 dedicated to operation and maintenance. In addition, the state of Utah will contribute $8 million for planning, design, and construction purposes. The legislation also authorizes the appropriation of $1 million for hydrographic surveys to complete the quantification of Navajo's water rights. This settlement is a good deal. It avoids risky and costly litigation, tough legal questions about how Navajo water rights fit into interstate compact requirements, and provides fair approaches in times of water shortages. As you may be aware, the Upper Colorado River Basin has endured numerous challenges, from protracted drought, reduction in water storage levels, endangered species requirements, and interstate and international compact obligations, to name a few. The settlement provides much-needed certainty that maintains the delicate equilibrium that is the law of the river in these challenging times. The settlement also addresses the United States trust obligation to the Navajo Nation to protect its water rights. The passage of this legislation will advance the commitments made in the Treaty of 1868, where Navajo leaders pledged their honor to keep peace with the United States. In return, the United States pledged to the Navajo people a permanent homeland.
Thank you, Mr. President. I'm afraid the time has expired, but thank you for your testimony. If you're able to stay for questions, we'll give you a chance to elaborate further. The chair now recognizes Mr. Johnson for 5 minutes.
Good afternoon, Chairman Huffman, Ranking Minority Member McClintock, Subcommittee members. I am Norman Johnson. I direct the Natural Resources Division of the Utah Attorney General's Office. I appear at the request of Governor Gary Herbert, who sends his regrets that he was unable to attend today. I have worked for 15 years with my Navajo Nation counterparts to develop the settlement that would be codified by H.R. 644, the Navajo-Utah Water Rights Settlement Act. I'm pleased to be here and to testify in support of an outstanding bill that represents years of good faith work by the state and the nation. I am especially grateful to Representative Bishop for sponsoring the bill both in the 115th session and again this year. I'm also grateful for Chairman Grijalva's support, and of course, it's a tremendous honor to testify and to sit next to President Nez. I suppose it's rare to have witnesses from both the minority and majority testify in favor of a bill, but I'm happy we can demonstrate the exception to the rule in this case. Utah and Navajo Nation officials have collaborated for many years to reach a consensus on a proposed settlement to quantify the water right claims for the area of the nation located within Utah. We prefer to negotiate solutions to federal reserved water right claims without having to file costly and unpredictable lawsuits. The Utah-Navajo Agreement contains a just, equitable, and reasonable resolution to Navajo water claims in Utah. This is particularly important because the water to resolve the claims must come from Utah's precious Colorado River allocation. Utah believes the 81,500 acre-feet of annual depletion the bill includes fits within Utah's allocation, thus helping to protect other water rights on the river that have priority dates later than those of the nation. The settlement also contains subordination language to facilitate the coexistence of Indian and non-Indian water rights in certain shared water sources. In 2015, the Utah legislature passed a resolution declaring support for the negotiated settlement of reserved water right claims, and particularly for the proposed Utah-Navajo settlement. Governor Herbert signed this resolution, and the legislature subsequently set aside a down payment of $2 million towards the state's $8 million contribution to the settlement, demonstrating Utah's continuing support. I believe H.R. 644 is important to all Colorado River Basin states because the nation's water claims in the basin are large and not yet fully quantified. All basin states benefit from having the nation's claims resolved within the allocation of the state where portions of the nation are located. New Mexico has achieved this type of quantification, and Utah will do so with passage of this bill. It is important that H.R. 644 be enacted as soon as possible. While the state of Utah takes no position on the other settlements being discussed today, we have worked hard to comply with the criteria that Representative Bishop wisely developed to ensure settlements are a net benefit to the U.S. taxpayer and have the support of the administration. As this committee considers next steps forward, I ask that you not delay or imperil the progress of the Utah-Navajo settlement by tying it to other proposed settlements that have not been as thoroughly vetted or have gained the administration's full support. I note that the money provided in this bill will be used to fund drinking water projects located on the reservation, which will improve the living conditions of Utah Navajo citizens. At the present time, as has been mentioned several times here today, many Utah Navajos lack the basic necessity of safe, clean drinking water. The bill will help construct infrastructure needed to change that. Further, the settlement provides, in exchange for the water and funding it recognizes, waiver of all of the nation's water-related legal claims against the United States, thus justifying the expenditure of federal funds. In short, the legislation represents an excellent example of what can happen when three sovereign governments work together in good faith to find solutions that benefit everyone. Thank you for your time and attention, and I'm happy to answer questions.
Thank you very much, Mr. Johnson. And prior to your testimony, I would have given the courtesy of inviting Mr. Bishop to introduce you. Since I didn't have a chance to do that, is there any post hoc introduction you want to provide, Mr. Bishop?
I am, oh geez. Okay, I'm very pleased to welcome the President and Mr. Johnson here.
Thank you.
And Gordon, you'll fill in the starts I didn't, everything else, right? Okay. All right. No, thank you for that courtesy, but I'm more than happy to have them here. This is one of those pieces of legislation. We have gone through all the traps. We are working very forward. We're working through it all. It's something I think is very important to get done soon, sooner rather than later. Thank you.
Thank you.
Chairman Clark, welcome. You're recognized for 5 minutes.
Hey, Hanga, Kamita, Yamul, Damon Clark, Sitka, Walbai, Mamuk, Bajawa, Nyam, Kamulva, It Sitka. Chairman Hoffman, McClintock, Gosart, members of the subcommittee, my name is Damon Clark, Chairman of the Waukee Tribe. Waukee Tribe strongly supports H.R. 2459, Waukee Tribal Water Rights Settlement Act of 2019. Waukee Reservation encompasses approximately 1 million acres in northwestern Arizona. Colorado River, we call Haka'ama, forms the 108-mile northern boundary of reservation, which is alive, which is our background, which is the backbone of our reservation, through a portion of the Grand Canyon. Our reservation has no significant surface streams other than the Colorado River, Haka'ama. It has very limited groundwater resources. The tribe's groundwater wells are being depleted, and well levels on the reservation has been dropping for years. Tribe's residential community at Peach Springs relies exclusively on 3 groundwater wells in the Truxton Aquifer near the reservation's southern boundary. Those wells were installed in 1975, so the piping in the wells system is 44 years old and has failed in recent past, leaving our community without water for several days. One of the wells has also suffered episodes of dangerous E. coli contamination. When that well is out of service because of contamination, we're unable to supply sufficient water to the community. We are very vulnerable to short-term interruptions in supply from these wells, and also to the long-term decline in the water levels in the aquifer. The situation is even worse elsewhere on the reservation. There are 2 wells at Westwater which have provided all the water for our tourist development 35 miles away at Grand Canyon West on the western rim of the Grand Canyon. But last year we experienced a crisis when the water table in these wells suddenly dropped because of the drought, and both wells failed. For the past year, collapse of these wells have forced us to limit our operations at Grand Canyon West, thus threatening our tribal economy and the main source of employment for our members. As an emergency measure, we have resorted to pumping more water from the Truxton Aquifer and hauling it by truck to get it to Grand Canyon West. This patchwork system is insecure and expensive, but it's the only way we can continue our remaining operations at Grand Canyon West. In this emergency fix has put additional stress on the Truxton Aquifer because we're now forced to use it to supply both Peach Springs and Grand Canyon West. Let me quote what our Tribal Director of Public Works said. This places an even greater demand on the public water system serving the community of Peach Springs. This leaves the tribe praying that the trucks don't break down, the pumps don't fail, the pipeline stays together, and there are no more E. coli events. The Colorado River, Haka'ama, is the only feasible solution to these problems and the only water supply that can satisfy the long-term needs of our population living in Peach Springs and on the rest of our reservation. This settlement would give our tribe an allocated 4,000 acre-feet of water a year of Colorado River and a pipeline system to deliver that water to the reservation. Passage of this legislation is essential for our tribe, if our tribe is to have a secure future on our reservation. This is for the future of our people. We have done everything possible to provide jobs and income to our people in order to lift them out of poverty, but the lack of a secure water supply is a major obstacle we still face. This legislation would very much help us to overcome this obstacle. Thank you for the opportunity to testify before you today. I'll be pleased to answer any questions you have, and our tribe will help in any way that it can secure enactment of this critical legislation. Thank you. Hanga.
Thank you, Mr. Chairman. Mr. Prushatsky, welcome. You're recognized for 5 minutes.
Good afternoon, Chairman Huffman, Ranking Member McClintock, and members of the subcommittee. My name is Tom Bushatsky, the Director of the Arizona Department of Water Resources. Thank you for the opportunity to testify on behalf of the state of Arizona on H.R. 2459, the Wallapai Tribe Water Rights Settlement Act of 2019. The state of Arizona supports H.R. 2459. The Wallapai Tribe is one of 11 of 22 federally recognized Indian tribes within the state of Arizona with unresolved water rights claims. Settling those claims is a priority for the state. Settlement avoids the cost and uncertain outcome of litigation and provides certainty to all water users in the state regarding their water supplies. The Wallapai Tribe has unresolved claims to both groundwater and surface water, including the Colorado River. The river is a critical water supply for agricultural, municipal, and industrial water users along the Colorado River in Arizona, as well as water users in central Arizona using Colorado River water delivered through the Central Arizona Project. To illustrate the importance of this resource, about 40% of Arizona's total water use is supplied by the Colorado River. The Colorado River is the only renewable water supply available to the tribe. The settlement provides the funding for infrastructure to put that renewable water supply to use on critical areas of the reservation. The use of renewable supplies instead of finite groundwater resources is appropriate for a permanent resolution of the Wallapai Tribe's water rights claims. The tribe's population center at Peace Springs is currently served from wells that are experiencing declining water levels. This renewable water supply will serve Peace Springs as well as economic development and new tribal housing at Grand Canyon West. The settlement will allow the tribe to continue on its path towards self-sufficiency. The settlement provides significant benefits by avoiding the costs and risks to the United States of litigating the tribe's water rights claim. The state of Arizona and its water users will benefit from the certainty this settlement achieves. Colorado River supplies the tribe will receive through the settlement will not affect the Colorado River entitlements of other water users in the state, because the tribe will receive a portion of the non-Indian agricultural priority Central Arizona Project water already being held by the Secretary of the Interior for Indian water settlements in the state of Arizona. Use of renewable water supplies instead of groundwater is consistent with the state's policy of preserving groundwater supplies for times of drought. Additionally, because the aquifer beneath the tribe's reservation extends to areas off the reservation, the tribe's use of a renewable water supply will help preserve groundwater supplies, not just for the tribe, but for the non-tribal water users in the region. Groundwater aquifers in this area of Arizona are limited, and natural recharge to replenish those aquifers is minimal. Substantial non-federal contributions to this settlement are being made by Freeport Minerals, the Wallapai Tribe, and the state of Arizona that are more than adequate to achieve a financial balance with the federal contributions. The state of Arizona's contribution is attributable to its obligation to firm the tribe's Central Arizona Project, non-Indian agricultural priority water, to a priority equivalent to municipal and industrial priority Central Arizona water through the year 2108. That estimated cost is $3.25 million. In conclusion, this negotiated settlement provides financial benefits to the United States and the Wallapai Tribe. It is a reasonable and fair settlement that will benefit the tribe, the state of Arizona, Arizona water users, and the United States, and would complete a comprehensive settlement of the tribe's water rights claims, building upon a prior settlement, Public Law Number 113-223, that became law on December 16, 2014. For all these reasons, the state of Arizona strongly supports H.R. 2459. Thank you.
Thank you, Mr. Bushatsky. The Chair I'll now recognize myself for 5 minutes to start the questions. And I want to begin by quickly addressing the references that have been made to the Bishop process, as it's been called, this idea that we need to subject Indian water rights to extra rigor and scrutiny to somehow protect the government and the taxpayer from potentially overpaying and entering into overly generous settlement agreements that are unfair to the government. I do not support that process. I find it to be a rank double standard. The fact that we are singling out a specific class of water users, holding them to special burdens and scrutiny and, frankly, a stigma. And these happen to be, for the most part, disadvantaged communities for whom we haven't got the most sterling track record of meeting our trust responsibilities. The idea that this is the one class of water users that we need to hold up to these special burdens and scrutiny is preposterous to me. And it has to be compared to the complete lack of scrutiny that we put on other water settlements that come before this committee when they involve non-native special interest groups that happen to be well-connected and powerful and wealthy. The poster child for that, of course, is the Westlands Water District and its drainage settlement, which some of my friends across the aisle tried to jam through the previous Congress. It involved more water than all of these Indian water rights settlements combined. It involved way more money than all of these Indian water rights settlements combined. It was hugely controversial. It had massive impacts that we were warned about by other stakeholders. The taxpayers for common sense and other fiscal advocates were in here telling us it was a bad deal for taxpayers, but wow, all of that fiscal vigilance evaporated and was nowhere to be found as folks were falling all over themselves to try to help the Westlands Water District without any scrutiny whatsoever. So I'm not a big fan of this notion that we need to single out Native American communities and make it harder for them to get running water and drinking water to their communities while we continue to give away the store to these groups which for decades have been heavily subsidized and lavished with favors by the federal government and by the United States Congress. I just wanted to get that one off my chest. Chairman Clark, the water rights settlement before us today quantifies Wallapi's rights to 4,000 acre-feet per year of Colorado River water for use on the reservation. And in your testimony, you talked about how this will provide opportunities for future economic development. I wonder if you could speak about what the tribe plans for future water uses once the reservation has access to this water.
Yes, thank you. You know, we've been placed on this reservation for a number of years, since 1883. We were there prior to that time, and all of a sudden, you know, we were taken off. When we were taken off, we were put in an encampment, brought back, and we found out that there was no water. So we started started with the housing project. We found out that there was ranchers there. They were non-native, so we had to take, you know, that back over. We found out there was a railroad station there, and, you know, they did water, Santa Fe water. So finally, you know, we started developing, and we got to the point at Grand Canyon West. We're looking at housing, we're looking at the infrastructure up in Grand Canyon West, because we lack, you know, the opportunity to develop. We lack jobs. But at Grand Canyon West, we're ranked #1 in the county. We're ranked #1 for employment. So we need to develop our water system there.
Mr. Chairman, what about the size of the project? The administration has expressed concern that current water use is only about 300 acre-feet per year. They've expressed concern that you may be perhaps making this thing too big. Could you speak to that?
Yes, We're not looking at just today, we're looking at the future. We're looking at our grandchildren that are not born, not even born. So we're not just looking at ourselves today, we're looking towards the future.
All right, I am out of time. The chair now will recognize Mr. Bishop for 5 minutes.
Thank you. Look, I don't want to be confrontational about this, but there's always means I am going to be. The protocols that we instituted are simply to make sure that the settlements that we go into will actually work, and they will not be litigated. And that's why it was based on a 1990 precedent that we've always been using. And that is that if you're going to have a settlement, that means that all players in the settlement are indeed have agreed. Two of those figures have to be the Department of Justice as well as the federal administration. So having those things added before allowed us to actually pass some settlements that would not have happened in the first place had we not tried to go through that. The process I have, though, is with the Navajo Settlement. We have gone through those. So I think, Mr. Johnson, President, as you'll all admit, that we have gone through that process, we've gone through the protocol, everyone is in agreement on this particular one.
That is correct.
On the other issues, on the other proposals, well, it hasn't gone that far yet. And it's not because we're any better in the process, it's just we've been working on it longer. This bill could have been passed last session had there not been some restrictions placed on the House which no longer are there. So the ability for this to go forward seems to be pretty good. President Nez, could I just ask you a simple question? One of the things that we have mentioned several times is that this is a fund-based settlement that provides more flexibility. Can you just provide me an example of how this flexibility will actually help the Navajo Nation?
Sure. Thank you, Chairman. Members of the committee and Representative Bishop, thank you for that question. You know, here is a prime example of Navajo Nation being able to work with counterparts such as the state of Utah and the federal government to bring a fair package for concurrence to our lawmaking body here in Washington, D.C. Now, we have approved previous water rights settlement, and to this day, as we speak today, members of Congress, we are building a water line project from the San Juan River. This is New Mexico, San Juan River, all the way to Gallup, New Mexico. And so we've done this before, and I appreciate the rules that were in place, and as was mentioned by Representative Bishop, we followed those guidelines at that time, and we've come to this Congress with the similar package, and rules do change, and I appreciate the words, Chairman, that, you know, reevaluating some of the rules is of utmost importance because of changing of the time. But here, we will bring in water to the folks in our communities that don't have clean drinking water. We have high levels of arsenic, we have high levels of uranium, that are in that region that are being pumped out. And here is a clean source of water. With all these dollars that are going to be committed on this legislation, we can see water going to the communities of Oljeto, Monument Valley, Navajo Mountain, in those areas. And that's clean drinking water, but at the same time, it's also for industrial use as well. So thank you for that question.
Thank you, President. I appreciate those.
Representative
Mr. Johnson, I've got just a little bit of time here left. You've been working on this as well from the
Yes.
Utahs. Do you have any qualms as to having actually crossed all the Ts, dotted all the Is, as we are moving forward on this particular proposal?
I have no qualms, Mr. Bishop.
The
Thank you.
state of Utah is comfortable with everything we are going to do and would be actually a positive for the state of Utah?
Yes, the state of Utah is fully supportive of the settlement.
Okay. Do you have any qualms how we package these, if this proposal was packaged with other proposals that probably have not had that same kind of scrutiny or the sign-off by the Department of Justice?
We would prefer that such packaging not slow down the Utah Navajo settlement. We would prefer that the settlement, that either the other settlements catch up with where we are, or that the settlement be able to proceed expeditiously.
Thank you. No, I appreciate that. And I think that's one of the purposes we had in trying to go through the protocols to try and make sure that that could proceed expeditiously. And without saying anything to Mr. Gosar or any of those who from Arizona, I hope the fact that you enjoy Utah's water because you're drinking our water when it gets to you. Nothing, never mind. I'll yield back. Thank you.
We're all in this together, folks. The chair now recognizes Mr. Gallego for 5 minutes.
Thank you. I want to thank Chairman Huffman for holding this hearing and our witnesses, especially our Arizona witnesses, for being here today. The settlements we are considering today are the result of years of hard work, negotiation, and compromise by all parties involved. Recognizing Indian water rights and ensuring reliable access to drinking water for tribes is both our legal responsibility and an essential part of respecting tribal sovereignty and self-government. And as we know in Arizona, it's also a matter of life and death. Settlements like the ones we consider today, especially for the Waukee tribe of Arizona, will ensure access to clean water for parts of Indian country that have long gone without a consistent, safe source of drinking water. Giving serious and timely consideration to the water settlements worked out by the tribes with state and local officials, stakeholders, and Congress what we can do in the face of federal government's historic failure to honor tribal water rights is important. That's why I'm glad this committee, with the leadership of my friend Chairman Grijalva, has recognized the need to move quickly to consider these settlements and ensure tribes have access to water for public health and for economic development. I look forward to working with members of this committee, my colleague, Representative O'Halloran, and leaders such as yourselves to ensure Congress quickly moves to approve these bills. With that, I have a couple questions for our witnesses. For Chairman Clark. Chairman, you testified that the groundwater wells used to support the Waukee tribe's tourist site at Grand Canyon West collapsed last year and are no longer producing any water. What problems has this failure of groundwater wells caused for the tribe, and what assistance, if any, has the tribe received from the Department of Interior or to help you deal with these problems in general?
Well, first of all, thank you for the question, Mr. Gallego. The groundwater, the wells did fail, and there is no more water going through there. So it does place a hardship. We are hauling water from Peach Springs to Grand Canyon West on a daily basis, costing thousands and thousands of dollars. That's the only way we can keep that place operating. Otherwise, we can't get anything else but from the Colorado River. That's the only supply we have available. In a conversation with a reporter, he asked me, so what's the thing? I said, well, Colorado River runs right behind our backyard, but we don't get one drop from it.
Because I only have so much time. Yeah. Is it correct that the Interior has done prior studies of groundwater on the Waukee Reservation?
Yes, they've done years of study.
What did those studies find?
That there's no groundwater. And they want to do more studies just to prolong the situation. That's not right.
If the groundwater is indeed insufficient, what alternatives has the tribe looked at as a solution to this problem?
Colorado River.
Colorado River. Now switching gears to Mr. Bishatsky, welcome. Your testimony describes this settlement as an important step in achieving Arizona's goal of settling all outstanding Indian water rights claims in the state. Can you explain why that goal is so important to the state of Arizona and why you're doing that, and what are you doing to meet that objective?
So Representative Gallego, clearly there are tribal communities that might have senior water rights to non-tribal entities, and again, settling those claims can allow you to move forward in a way that you can minimize that impact of the tribal water as they start to use it pursuant to the settlement. You can get the buy-in of the local stakeholders and regional stakeholders who are going to be impacted by that outcome and the award of water and infrastructure to use that water to tribes. So the state is currently in negotiation with the Tonto Apache tribe, Yavapai Apache Nation, Navajo and Hopi tribes, and we're trying to move forward with those tribes as well to further close that gap on the settlement on the tribal claims that have not yet been settled.
Great, thank you. I yield back my time, Mr. Chairman.
Thank you. The chair now recognizes Mr. Gosar for 5 minutes.
Chairman Clark, it's great to see you again. Now, you testified that the Wallapai tribe should not be forced to accept a settlement where they rely solely on groundwater from wells, especially well water levels that have declined, and that the tribe's experts estimate they can only sustain the tribe, even at the best, 30 to 40 years. As the gentleman from Arizona as well said, you know, you had failure on on several of the wells last year. Can you elaborate on why you believe groundwater as a sole solution and Phase 2 settlement is not a realistic long-term solution?
Well, at the present time, you know, there's a development down in Kingman, and they're taking a lot of water from the aquifer, and they're selling, you know, a product overseas. Kingman in that area is looking for water as well. There is nothing. It's getting depleted, the area we're at.
Now, can you elaborate why a reliable water supply for the tribe's main population is so important?
Well, water is life, and without water, we wouldn't be able to survive in the area. With the Colorado River, which is life running, we would be able to continue and prosper.
You heard my questions for panel one. Does the tribe agree with my assessment as to that allocation from Freeport?
Yes, it is. It is an allocation. The tribe is going to do something as well. We have to do the infrastructure for, you know, getting the water there too. So we have a part say in there. And Freeport, you know, without them giving that amount of money, we wouldn't be here.
Pretty good deal all the way around, wasn't it?
Yes.
Yeah, and everybody held to the letter of the law, did they not?
Yes.
Yeah. Director Bashofsky, it's great seeing you again. And thank you in regards to your leadership in the drought contingency plan. As you stated, maybe a little bit better, we had some problems. Not that we couldn't overcome them, but because we didn't have some Indian water settlements in that process. Can you elaborate a little bit?
So I think in that process, the number of constituents were many more than the parties to this settlement. But I think we showed in that process the value of building consensus as we have in this settlement in terms of the local parties, county government, Mojave County, the tribe, the state, coming together with discussions with Interior, with the federal government, to put together a fair and equitable settlement for everyone involved.
Would you agree with my assessment earlier in talking to Mr. Mickelson as far as the allotment?
Representative Gosar, yes, we agree. We calculate the non-federal contribution to be $54 million, which is about 40% compared to the federal appropriation for the pipeline. So the money from Freeport, the tribe, who will be putting in $40 million approximately for power lines and power to pump the water, and then the state of Arizona's contribution. So the non-federal contribution is substantial when you include all of those, including Freeport's dollars.
Phase 1 was economically proven to be beneficial to all groups. Is that true?
Yes, I believe so.
President Nez, in the time I have, can you elaborate on the importance of securing the nation's water rights in Utah and why H.R. 644 is so important?
Thank you, Chairman and members of the committee and Representative Gosar. Thank you for the question. I just mentioned that earlier in my comments that getting clean drinking water is important to everyone at the table. And I think we have spent considerable amount of time negotiating this settlement, that we all believe it's fair and equitable to all parties. And all of us support this agreement, this settlement, and now is the time. I know there was a question or a comment made about how is it going to affect the taxpayers out here. We've been going back and forth, and this is the same thing with Arizona about going into the courts and trying to resolve these issues and millions of dollars going into litigation. Here's an opportunity for all of us, not just Navajo, but all the folks that are up here, to settle a water rights that can save dollars and to be able to put clean drinking water into our communities that are in need. Thank you.
Thank you, Mr. President. Time's expired, Mr. Kozar. Thank you. The chair now recognizes Ranking Member McClintock for 5 minutes.
Thank you, Mr. Chairman. First of all, the subcommittee and the full committee, for that matter, have been regaled for endless hours and many years with the chair's running feud with Westlands, but the implication that the different approach is racial, I find deeply offensive and flat out wrong. The principal difference, of course, is that the projects involved in the San Joaquin are financed based on the beneficiary pays doctrine. Ultimately, the beneficiaries, the users of the water, pay for those projects and not the taxpayers. Here, of course, the taxpayer pays, and the reason is because under the Winters Doctrine, the government has a responsibility to assure that the water resources that are provided along with the land as part of our trust obligation. Now, we have 3 bills before the committee today. We've not heard any witnesses on the Amat bill. And the reason we haven't heard any is because we're frankly over the barrel. We made a bad deal. We agreed to a project rather than a total settlement amount. We thought we were agreeing to $50 million. It's now going to cost us over $200 million. And there's nothing we can do about that. We made a bad decision. Now, we have 2 other bills before us today. We have the Navajo bill, where the government estimates that the taxpayer liability is at least $250 million. Instead of going to court, the Navajo are settling for about $210 million, as I understand it. That's a good deal for them. It's a good deal for the taxpayers. It is fair, it is equitable, and it discharges our responsibility to the Navajo on the Utah lands. But then we have the other bill, the Wallapai bill, and that is where the government is estimating we have a liability of about $60 to $80 million, and yet we would be agreeing to a project that they're estimating could be as high as $340 million, 4 times more than the liability we actually bear. So, Chairman Clark, my question to you is this. It's pretty clear the bill, if it got to the president, would be vetoed. So there's no resolution to that issue. The government feels it's liable for between 60 and 80 million. You want 340 million. Why don't we go back to the negotiating table and figure out an equitable amount that protects both the tribe and the American taxpayer?
Thank you, Representative McClintock. That isn't our estimate. That's from the DOI. That's from
No, I understand that, but
yeah.
what they're telling us is your estimate is frankly lowballed, and it's still much higher than the high-end liability the government thinks that we have to provide these resources for the tribe.
We had a reputable study done by Dow Industry, and they were right on. I mean, we've done studies at 3 locations, and the best one was from the Colorado River at Diamond Creek. Now, that was a 2016 study. Mm-hmm. Today, it might be a little bit higher because we haven't done anything for the past, 3 years. And because of that...
It's pretty clear the administration is not going to approve this bill. So what's your plan here? At the end of this whole process, you end up with precisely nothing.
We asked that the BOR give us a study and see what their numbers are. We've never
They've just told you what their
anything.
numbers are, 60 to 80 million.
They haven't given us anything.
Well, he just...
We were told to give them something, but we haven't gotten anything back.
Well, he just told us that they estimated to be about 60 to 80 million dollars to fulfill our responsibilities under the Winters.
I'd like to ask you, did he show you that study that they did?
No, but
Okay, I
that's
haven't
what he
seen
just
it either.
testified to this committee. My point is that I think you need to go back and negotiate this and then make a decision. Once you've arrived at a level of funding, then you have to decide whether or not to accept that funding or to take it to court.
They gave us an
It's
estimation.
just as, by the way, on the government side, has to make the same decision.
They gave us an estimate, half of the cost of what we were asking for,
But you're-
178.
You hear the concern is that the amount that is in this bill, first of all, is well beyond what is required to actually fulfill the winter's obligations of the government, and is more than 4 times higher when all of this plays out, because they're telling us that, no, this project's going to cost a lot more than what we've got in this bill.
I respectfully say that's not true.
Well, I would respectfully suggest that if you actually want to resolve the issue, you need to go back and open negotiations and come to us when you've had a meeting of the minds. And if there's not a meeting of the minds, then take it to court. You may get the $340 million. But you know, our responsibility is to meet our obligations under Winters, but it's also to protect the taxpayers. Anyway, I'm out of time. Yield back.
I thank the ranking member, and thanks to the witnesses for their valuable testimony and the members for their participation and their questions. The members of the committee may have some additional questions for our witnesses, and we will ask you to respond to those in writing under Committee Rule 300. Members of the committee must submit their written questions within 3 business days following the hearing, and the hearing record will be kept open for 10 business days to allow for the witness's response. If there's no further business before the committee, without objection, the committee stands adjourned. Thank you.